How do the 1954 Act bad tenant grounds for opposing a new tenancy fit with a claim for forfeiture? So the bad tenant grounds A, B and C in section 31 of the Act are A, broadly, that the tenant ought not to be granted new tenancy in view of the state of repair of the holding, or B, that the tenant ought not to be granted a new tenancy in view of his persistent delay in paying rent, or C, that the tenant ought not to be granted a new tenancy in view of other substantial breaches by him of his obligations under the current tenancy, or for any other reason connected with the tenant's use or management of the holding. So they look a bit like forfeiture grounds. The tenant is a bad tenant, they've been in breach of some sort of covenant. But in some senses, they're less useful than forfeiture. You have to wait for the end of the term in order to take advantage of the grounds of opposition. And they're discretionary. The court has to be of the view that the tenant ought not to be granted a new tenancy. But in other senses, they're easier to satisfy and more useful. And some of that stems from the fact that in a forfeiture proceedings, you're bringing about a term to an end earlier than its ordinary expiry date, whereas in a bad tenant ground opposition case, you're just saying that you don't want there to be a new tenancy at the expiry of the existing term. So they're doing slightly different things, but they're more useful in various respects. Even if the tenant pays rent, a past persistent failure to pay rent can be enough. There's also no Section 146 formalities to follow, although you do have to have a Section 25 notice. You don't have to worry about accidentally waiving the breach. And there's no relief from forfeiture, so there's no period of uncertainty, and there's no, apart from appeals that is, and there's no right for the tenant to remedy the breach and get the premises back. So what can happen is that a landlord might want to run some of these simultaneously, alongside each other, forfeiture and bad tenant grounds, when you're nearing the end of the contractual term. But how do you do that? Well, Reynolds and Clark at one point seemed to be of the view that forfeiture proceedings will delay bad tenant ground proceedings, and that often a landlord would be better advised to proceed with the 1954 Act opposition alone. However, it ought to be possible to run two sets of proceedings together, but doing so is far more awkward than really it should be. And that's because of two related issues. So first, there's a waiver issue. The tenant is in breach of the terms of the lease. So the landlord serves a Section 146 notice, or doesn't have to if the breach is only a failure to pay rent. So the case is now primed for a forfeiture claim to be issued. But if the landlord serves a Section 25 notice, does that waive the breaches for the purposes of forfeiture? Hill and Redman, if you look it up, they say no. But they rely upon a case called Baglabasi and Deed Method, where the claim for forfeiture was made first, and then a Section 25 notice was served. And it was held there that the landlord was entitled to serve a Section 25 notice, even though it had elected to bring the lease to an end. There was nothing inconsistent about the landlord's intention. In both cases, it was wanting to bring the lease to an end. So that's helpful to the landlord. The purpose of a Section 25 notice is to bring the lease to an end, and a Section 25 notice can be validly served even if forfeiture proceedings have been issued and without prejudicing those forfeiture proceedings. But the case doesn't say in terms what Hill and Redman says it says, namely that a Section 25 notice served before forfeiture proceedings are issued won't waive a breach. Okay, so let's look a little further. It's been established that a Section 146 notice doesn't waive an earlier breach by failure to pay rent. And the basic reason for that is that the Section 146 notice is consistent, again, with the landlord's intention to bring the lease to an end and doesn't depend upon the existence of the lease. It's a case called Church Commissioners and Nojumi on that. But it is also the case that service of a contractual notice to quit does waive the breach. And that's because in order to do so, the landlord is positively relying upon the continued contractual term in the lease. Now, on balance, I think a Section 25 notice won't waive the breach, even though it will say, I am giving you notice under Section 25 to end your tenancy on whatever date is specified. That's doing something a bit different from a contractual notice to quit. It's not purporting to exercise any term of the lease, but rather just to get statutory protection out of the way, a bit like a Section 146 notice. But the position isn't clear, and landlords would certainly be running a risk if they served a Section 25 notice after the Section 146 notice, but before issuing and serving a claim for forfeiture. And I say serving a claim for forfeiture, that's important because it's the service of the claim for forfeiture that amounts to an unequivocal election to treat the lease to an end and to forfeit it. Okay, so there's a risk. So in an ideal world, what a landlord would do would be issue the claim for forfeiture first, bank it, protect it, and then think about the bad tenant ground 1954 Act opposition. So the next issue is a procedural one. If the forfeiture claim has to be issued first, how can the 1954 Act opposition be run alongside? Now, one answer would be to issue a second set of proceedings and seek to have them consolidated. And that would probably work, but two sets of proceedings can be really messy. There's a risk, we've all seen this, there's a risk of not managing to get them consolidated efficiently, one of them gets lost, the whole thing might drag on, etc. And that can be really defeating landlord's interests. There also might just be a risk that issuing a fresh set of proceedings, which in essence says, in terms, we are the landlord, the defendant is the tenant, we oppose the grant of a new lease, looks rather like affirming the lease and waiving the breach. It doesn't feel good, doesn't look good. So I think the safer approach is to serve a Section 25 notice, making it clear that it's without prejudice to the forfeiture claim, and then apply to amend the forfeiture claim to run the 1954 Act ground. And that amendment ought to be quite straightforward. It is introducing a new claim, so it's a special kind of amendment, but under Part 17 it would be in the interest of justice to do so. You're keeping the whole dispute in one place, and that's a good idea. And you can also line it up in advance. A landlord can be quite straightforward with the tenant, even before issuing the forfeiture claim, explaining that the intention is to run both arguments together, but this cumbersome process is necessary to avoid any argument that there's been a waiver of the breach, so the tenant can expect a Section 25 notice and an application to amend shortly. And by being upfront, the hope is that issues on amendment ought to be minimised. Now, I think this is a cumbersome and unfortunate situation that landlords might find themselves in, but that's the best way I've seen of dealing with the problem. But if you have any thoughts, if you've done it different ways, I'd be really interested to hear and to learn of what success or issues you've encountered along the way. So please do get in touch.